Hello, everyone. This presentation is about the on-site non-potable water systems rulemaking, a new chapter to Title 246, Chapter 246-275, on-site non-potable water systems. I'm Jocelyn Jones. I'm the rule writer and project manager for the on-site non-potable water systems rulemaking. And these lovely people, Brian, Mamdu, and Steve, are the other members of the environmental public health team working on this rule. The entire series of recorded presentation segments will include what you see on this slide. First segment will be an introduction with a high-level overview of rulemaking in general at the Department of Health, DOH, and the on-site non-potable water system, or ONWS, rulemaking specifically. That is this segment. The remaining presentation segments are high-level overviews of the draft rule by parts. I broke up the longer presentation into these shorter segments to make viewing it all a little more tolerable in general, but specifically so you can view each segment along with the draft rule language, pausing where and when you need to take notes or look more closely at the draft rule language so you can formulate comments and suggested edits. We're counting on you to tell us what we got right and what changes you think would make the draft rule better. So this is what you will cover if you view each presentation segment, which I hope you will do. But if you do have time constraints, feel free to focus on the parts that are in your area of expertise or where you think your time and effort has been spent to provide the most salient and substantive of your concerns. To kick things off, I'll start by giving a brief introduction to rulemaking at the Department of Health. If a bill passes out of both the U.S. Senate and the U.S. House, it gets signed by the President. And that's how a bill becomes a law. Schoolhouse Rock tells this perilous tale in a much catchier way, but I use this example because although Schoolhouse Rock is singing about the federal legislative branch, it works essentially the same at the state level. The state legislative branch, the State House of Representatives, and the State Senate pass bills that are signed, or not, by the governor, who is head of the executive branch. Cabinet state agencies work on behalf of the governor as part of the executive branch to implement laws or statutes. These are all different ways of saying the same thing. You might even hear them called acts. But law is a statute and statute is a law. And in Washington state, these are all collectively known as or contained in the Revised Code of Washington. So now when you see references to RCWs and WACs, you know what they mean and how they are different. So in general, all rulemaking is governed by two specific statutes. The Administrative Procedures Act, what we call the APA, which is Chapter 3405 RCW, and the Regulatory Fairness Act, or RFA, which is Chapter 1985 RCW. These two statutes guide much of the rulemaking process for the department as the APA applies to all rulemaking. The APA contains the detailed requirements for each type and phase of rulemaking, including that for public comment, public hearings, and public notifications. Additionally, the APA requires the department to prepare and provide for public comment a preliminary cost-benefit analysis. The agency calls this a significant analysis, and in this analysis, the agency considers both the qualitative and quantitative benefits and costs of the rules. We also look closely at the different alternative provisions we've considered and determine whether the rule provisions we are proposing are the least burdensome requirements that will achieve the general goals and specific objectives of the statute that the rule implements. The preliminary analysis is made available for public comment when the agency proposes a rule, and the final analysis must be made available when the rule is adopted. The Regulatory Fairness Act applies only to rules that impose a compliance cost on small business. If there is a disproportionate impact to small businesses, the agency must mitigate however is legal and feasible, and we must make available a small business impact statement. This is also put out for public comment, with a final version being made available upon rule adoption. So why and how does the Department of Health conduct rulemaking? Well, initially something prompts a rulemaking. So a change in a federal or state law. It could be feedback from interested parties. It could be court decisions, new technology or science, petitions from citizens or organizations and associations, or it could just be the result of a periodic review done by the agency. Once it is decided that a rule needs to be amended or revised, or in the case of a new rule like the on-site non-potable water system rule we're talking about today, created, the agency announces our intention to begin a rulemaking by filing a CR 101 pre-proposal statement of inquiry with the Code Revisor's Office. That's what the CR stands for in CR 101, Code Revisor. Sometimes we will form a Rule Advisory Committee, or a RAC, R-A-C, to engage with interested parties, regulated parties, or others who may be interested in the topic of a rulemaking. We send out email notices to folks signed up for the issue the rulemaking is addressing and post information on our website. Next, we have this last section, develop proposed rule language. This is where we really start to dig into the rule development. It is still officially part of the CR 101 phase. There's no time limit on how long this phase can take. It's highly dependent on the topic, the level of controversy, and engagement among interested parties. But during this time, we work closely with the Rule Advisory Committee, or RAC, if there is one, tribes, regulated parties, and really anyone else that's interested in the rulemaking to develop draft rule language. We sometimes hold workshops, meetings, informal comment periods to get feedback on our ideas for the rule. Once we have a draft rule that we think is where we want it, we move to the next phase. All right, next we have the CR 102 phase. A Notice of Proposed Rulemaking, or CR 102, is filed with the Code Revisor's Office. This opens the formal public comment period and provides details about a public hearing, which is a formal opportunity to provide oral comments to the agency on the draft proposal. Additionally, at this time, we include as part of the public comment period the preliminary significant analysis and, if required, the Small Business Economic Impact Statement, or SBEIS, I talked about a couple of slides back. After the public hearing and the close of the formal public comment period, the agency must consider the comments we receive, and a decision must be made as to whether we will adopt the rules as it was proposed, or if there are changes that need to be made in response to the comments that we received. If the changes needed are substantive in nature, meaning the change is large enough that the regulated parties need another opportunity to review and comment on those changes, then we must return to the CR 102, Notice of Proposed Rulemaking, and refile the CR 102 form and allow the public an opportunity to comment on the new proposal that would include those substantive changes that the agency made in response to comments. However, if we've done our due diligence working with interested parties during the rule development phase, the changes we need to make likely won't be substantive. If this is the case, we can note any non-substantive changes, like correcting typos or making changes that make requirements clearer or more concise. So if any of these are being made, we note those on the CR 102 form we file with the Code Revisor's Office when we adopt the rule. We also make note of these non-substantive changes in the CES, or the Concise Explanatory Statement, which is again the agency's response to comments that is required under the APA. Once the CR 103 rule adoption notice is filed with the Code Revisor's Office, the agency will post the rulemaking materials on the Office rulemaking webpage and send out notices in compliance with the APA that announce the rule adoption, providing an effective date and directing interested and regulated parties to the concise explanatory statement and other rulemaking documents available on the webpage. Typically, adopted rules become effective 31 days after adoption, unless otherwise specified on the CR 103 form. These are what we call delayed effective dates, and they are allowed in the APA and sometimes used to give regulated parties and others an opportunity to prepare for the new requirements. Next, we'll go over a little bit about the on-site non-potable water systems rulemaking. All right, so what is the on-site non-potable water systems, or ONWS, rulemaking all about? The Department of Health, DOH, is implementing a law that was passed in 2021, ESHB 1184, concerning risk-based water quality standards for on-site non-potable water systems. This was codified as law in Chapter 90.46.290 RCW. This law or statute directs the Department of Health to set water quality and risk-based standards for the use of on-site non-potable water systems at certain scales, such as multifamily, mixed use, commercial, or district scale projects, and the subsequent treatment non-potable water can then be used for, things like landscaping, irrigation, and even toilet flushing. So just to take a step back real quick, what's the difference between potable and non-potable water? Potable water is safe for drinking and meets the Federal Safe Drinking Water Act standards. Treated non-potable water, while not safe for drinking, when treated by an ONWS or an on-site non-potable water system to the standards that are being established in this draft rule, it is safe for many end uses where drinking water is not needed. Purple pipes are used to distribute treated non-potable and reclaimed water to distinguish it from drinking water piping. So with that distinction between potable and non-potable, we can now turn to what is an on-site non-potable water system. An on-site non-potable water system is a treatment system technology capable of treating the non-potable water, the wastewater, the rooftop runoff, the stormwater, so that it can be used for things that don't need drinking water. Again, like landscape irrigation and toilet flushing. You see, right now, most buildings use potable water from the municipal source or a well. However, these other sources I've mentioned can be captured and used as an alternative to potable water when potable water isn't needed. This is what is meant by the right water for the right use. So this brings us to the goals for this particular rulemaking. We first and foremost need to protect public health. We have to establish standards so that the right water for the right use can be accomplished. We want to preserve flexibility so we can encourage innovation. We want to support local capacity development, and we want to create a core of professional engineers and operators capable of running on-site non-potable water systems all across Washington state. Now, this rule may not do this last one all by itself, but we do hope that having a rule in place will be a driving factor for developing a core of professionals capable of running these systems. So this brings us to the end of the first presentation segment. If you have any questions, please join us for one or more of our upcoming Q&A sessions coming soon, or reach out anytime. Here is my contact information, jocelyn.jones@doh.wa.gov or 360-236-2030. Thank you so much for taking time to watch and listen to this portion of the presentation. I hope you'll watch the others as well. I do hope the information is useful and that this format is working for folks. I hope to hear back from you all in the form of comments or at an upcoming Q&A. Thanks so much. And as always, to request this document in another format, please call 1-805-525-0127. Deaf or hard of hearing customers, please call 711 for Washington Relay or email civil.rights@doh.wa.gov. Thank you again for your time and attention.